was null and void, even if the claim of the defendant was based on a registered deed of adoption. The learned counsel has submitted that these aspects of the matter have not been properly considered by the court, and further the court have also held that the suit was barred by mutation. He submits that the plaintiff came to know about the deed of adoption for the first time in 2005, and they filed the suit in 2005 itself, and therefore the finding of the learned court that the suit was barred by mutation is itself perverse, and it calls for interference by claiming a substantial issue. The learned counsel has also relied upon a judgment passed by Patna High Court, reported in KIR 1977, Patna 199. Though dealing with the adoption under Hindu Adoption and Maintenance Act, and I submitted that giving and taking ceremony is essential for a valid adoption. After hearing the learned counsel for the appellant, this court finds that the suit was filed challenging the registered deed of adoption dated 16/11/1978/8/12/1978. And a declaration was sought that the same was null and void. The plaintiffs claimed right title and interest over the suit property. It was the specific case of the plaintiff that since Khare Murmu had died issueless, the property would devolve upon the Arnets, and the claim of the defendant on the basis of registered deed of adoption by Khare Murmu was null and void. as per the plaintiff, the cause of action arose on 26/9/2005 when the plaintiff came to know about the adoption. The trial court framed the following issues for consideration. So far as the learned counsel has in particular referred to the issue number 2, 3 and 4 framed by the learned trial court. Both the parties named the plaintiff led oral and documentary evidences before the court. The details of the oral and documentary evidences based on record has been mentioned in paragraph 9 of the appellate court judgment, which is as under para 9 to 15. The trial court ultimately held that the parties are cousins amongst themselves, and as per the customary law, in case of person dying issueless, he can adopt a son. The court also recorded that the plaintiff were aware about the registered deed of adoption, about the adoption, but they did not take steps within 3 years of their knowledge, and ultimately the court held that the suit was barred by litigation. The court also recorded that the required ceremonies for adoption were duly performed, and ultimately held that the registered deed of adoption dated 16/11/78/18/12/78 is neither forged nor fabricated and is not fit to be declared null and void. And the plaintiffs are not entitled for any relief and consequently dismiss the suit. So far as the first appellate court is concerned, the same points were taken into consideration. The first appellate court, by deciding issue number 1 and 2, has elaborately dealt with the oral and documentary evidences led by the parties and held that the plaintiff had knowledge of the adoption deed as back as on 21/6/2000. But they filed the suit for its cancellation in the year 2005 and held that the suit challenging the deed of adoption is barred by litigation and found that the trial court has not committed any error by deciding issue number 1. The discussions in connection with इसको जरा quote करें. The discussion in connection with the other issues, that is issue number 3 to 8, were taken up by paragraph 14, and the court discussed all the oral and documentary evidences and recorded finding in paragraph 15 as follows. Support that. This court finds that both the learning courts have held that there are customs in Santhal to adopt a son if a person dies childless, the plaintiff Sonal Murmu and Patwari Murmu himself accepted the adoption of Munila Murmu by late Khade Murmu in a Karanama dated 21/7/2000, which was signed by both the plaintiffs. Semicolon. Exhibit B by 1 is a registered deed of adoption, which was clearly written that Munila Murmu adopted by late Khade Murmu in the year 1978. And Exhibit C showed whether many revenue receipts which showed that Munila Murmu paid revenue to the government and was cultivating the share of the current. The court held that there was neither any fraud nor impersonation in connection with the adoption deed. And ultimately, because of the view that the learned trial court has not recorded any illegality in dismissing the suit and confirmed the findings of the learned trial court. This court finds that both the courts have considered every aspect of the matter by dismissing the suit. And the fact remains that suit was held to be barred by limitation after considering the oral and documentary evidence on record. And the adoption deed in the present case was a registered document. This court finds no illegality in this court finds that there is no substantial question of law involved in this case, according to the previously discussed.
Item 48, second to latest law 2021.
What is the matter? Why is it not available? Yes. Register file. He's sitting with the file in court number 6. He's sitting with the file in court number 6. Sorry. Where is your file of this case? Where is your file? What's your name? You tell your senior that you will never stand before this court without a file. If he does not give you the file, don't come. You tell him that I will not come, let the case be dismissed for you. No, I dear man. I'm sure the court number 6, whichever court it is, will not say beyond 4:30, right?
Yes.
All right.
Item 49, second bill 102 of 2022.
Yes, madam.
Paying for a short parcel.
No, what entity is from the council?
So Mr. Sani himself to the admin.
I have appointed you a Marcus, now you are fit to argue this. Right?
Actually, I read the file, but I'm not fully aware of the facts.
Sorry?
I'm not fully aware of the facts which.
You can't have this. If you want more appointments as a Marcus, then you cannot cut an excuse that you are not aware of the facts. Then you are not fit to become a Marcus in other cases. Isn't it? The fitness would be under question. No, I will not undo this. My expectations are very high from you. So you cannot, you cannot afford to live, not to live up to my expectation. What is the matter? You are a plaintiff or the defendant? Plaintiff or the defendant?
Plaintiff.
Where is your file? Where is your file? Have you filed?
Yes.
You are a plaintiff or the defendant?
I'm plaintiff in this matter, otherwise I'm defendant in the trial court in the appeal.
So was agreed.
Yes, Mr. Yes, Mr. It was agreed. Page number 66. It's titled Suit 28 of 2009.
Okay, I'll post it tomorrow, but tomorrow I'll not give any answer. Okay. If he comes, it's okay. Otherwise, you are.
Yes, Mr.
SC number 102 and Ms. Krishna Shagar Amir. Please listen.
सॉरी हम 47 देख रहे थे तो सोचे कि 49 है मेरा इसलिए मेरा 3 नंबर में नेक्स्ट केस था कंफ्यूजन in this case not the defendants are the appellants. The suit was filed by the plaintiff respondent for declaration of title and confirmation of possession and for recovery of possession over item number 2 of Schedule B. This is the relief sought for. The case of the plaintiff respondent, as made out in the plaint, is that the property belongs to one Radhu Napit, who is the common ancestor of both parties. Radhu Napit died leaving behind two sons, Mohan Napit and Chutu Napit. Then Mohan Napit had two sons, Yugal Napit, who died leaving behind his widow Ludhi Napitani, and another son died issueless. So the only son Yugal, who died leaving behind widow Ludhi. So far Chutu Napit is concerned, he died leaving behind his Gangadhar and the leaving behind 4 plaintiffs and 2 daughters. They are defendant number 17 and 18. Now the land recorded.
Gangadhar is also one of the plaintiffs.
Yes, the
Four
plaintiffs.
sons.
Plaintiffs are the 4 sons of Gangadhar.
So
Gangadhar.
Chotu had a son named Gangadhar.
Gangadhar.
He had 4 sons.
Gangadhar had 4 sons. They are the plaintiffs, and 2 daughters. They are defendant number 17 and 18. Now the further case is that the Gangadhar sold 5 dismil of CS plot number 2973 to Amodi Devi. Then Hari and others with vision attended the plaintiff from they dispossessed the plaintiff from plot number 2993 and 2953 under Khata numbers 36. according to them, the 24th of January 2029, the Ludhi, the one legal heir, remaining legal heir, she surrendered the land to the landlord, and then in turn, by registered deed on 29th of March 1931, it was settled to Syam and Harku by registered deed. C, and therefore their case is that the settlement was illegal. This is the case of the plaintiff. Our case note is that defendant's case, that Sambhu died issueless, Yugal inherited the entire property and that was devolved into Ludhi as widow, and 1929 it was surrendered to the ex-landlord. 1931 ex-landlord settled by registered deed to Syam and Harku, ancestors of the defendant. We are the legal heirs of the settlers. By registered deed of settlement, it was settled to our ancestor.
So
Now,
there are two registered deed of settlement.
one is surrender.
29,331 is surrender. No, it is also a deed of settlement.
Deed of settlement.
Yes.
Deed of settlement.
In favor of Haragam.
They are our ancestors, defendants' ancestors.
Okay.
Now the plaintiff made out a case. The registered settlement of 1931 is wrong, is illegal.
Okay.
Then not, if you may kindly see, in 1998, Kausalya died leaving behind the defendant. That is the
That's right. So basically all revolves around this settlement.
Settlement. Now, if you may kindly see for a moment the trial court judgment, subject to Lordship's
What is
kind
the
pleasure.
finding and condition?
Yes, that is the reason. Para 5 is the issues, trial court judgment. Para 5, page 19.
Yes.
Page 19. Trial court judgment.
The judgments are running, each paragraph is running in several pages.
Yes.
20 pages, one paragraph.
Yes, sir. Your Lordship will get the issues at page
Yes, I got it.
para 5. There are not as many as 8 issues, to 12 issues. Out of them, your Lordship may kindly see
8.
issue number 6 relates to whether Gangadhar, father of the plaintiff, acquired title. So the 8 man.
8.
8. Whether the deed of settlement dated 23/3/1931 alleged to have been executed by the then landlord in favor of Syam Napit and Harku Napit is valid. Now, in this regard, the Lordship may kindly come to me, Lord. Para 7, page 23 of the trial court judgment. Para 7. Issues number 6, 7 and 8. All 3 issues were clubbed together. These issues are main issues and interlinked to each other, which need to be discussed such and such. I have gone through the entire evidence, as well as oral as well as documentary, and found that admittedly the suit property is situated such and such, such and such. Both parties admitted that Radhu Maji was the common ancestor of the plaintiffs and pro forma defendants, and he died long ago, leaving behind 2 sons, namely Mohan and Chutu. Mohan died leaving behind his 2 sons, namely Jugal and Sambhu. Jugal died issueless, leaving behind his widow Ludhi Majer, who was a minor at that time. Sambhu also died issueless. Both parties have given contrary evidence with reference to death of Jugal and Sambhu, but there is no any effect in the case to the years of death of Jugal and Sambhu. On the other hand, both parties further admitted that Chotu Maji died leaving behind his only son Gangadhar Maji. It is the pertinent to mention here that the Jugal Maji, Sambhu Maji and Gangadhar Maji are admittedly recorded real. Further, Gangadhar Maji died leaving behind his 4 sons, namely Jagannath, Balaram, Sitaram and Janmejja, and 2 daughters, namely Sathi and Padma, who are the pro forma defendants. Admittedly, plaintiffs are only rightful owner of Khata number 6. The owner of Khata number 36 are Jugal Maji and Sambhu Maji. We are the descendants of Sambhu Maji. Now, Sambhu Maji, the land of CS Khata number 7 is joint property of sons of Mohan and Chotu. Both parties have also admitted that the wife of Jugal Maji, namely Ludi Majwai, was minor at the time of death of her husband Jugal Maji. The case of the plaintiffs is that when Jugal Maji died at that time Sambhu Maji was alive. And after death of Jugal Maji, his share is devolved upon surviving brother.
There is a finding that she had no.
Now, if I put a question to myself, in 1931, it was registered. Surrender followed by registered deed. In 1929, it was not surrender, registered deed. Then 1931, it was settled. Now, this question, it is through the guardian, legal guardian Harun Maji. That is the surrender. That has also come. But this aspect of the matter is not come. Your Lordship may kindly see, there was incapacity, but it has been validated by virtue of efflux of time. There are two things. One is void, another is voidable. If I accept the contents, one is void. If there was no right to surrender, no right to settle, in such case, here it is a surrender if it was wrong in 1929, which was voidable document if I accept the contention also. Then in 1931, by the time, it was settled by the ex-landlord. And ex-landlord, when it was surrendered, this is one aspect. Then we learn if the invalidated document, invalid document or voidable document has been validated by virtue of a registered deed of settlement in 1931. But in 1931, if the document was illegal, the Lordship may kindly see, the suit was brought in the year 2012. The document is under not challenge. If Lordship may kindly see for a moment.
What is your question?
Now, the Lordship may kindly see question point number 8, 9 and 13. 8, 10 and 13. Subject to Lordship's kind pleasure.
आप सब्सटैंशियल क्वेश्चन ऑफ लॉ एक पन्ना का बना देंगे तो
होना चाहिए था लेकिन मेरा ट्रांसफर
इतना बड़ा एक
वही हम भी देखते हैं हम नहीं बनाते
आप नहीं बनाते
नहीं हम छोटा सा बनाते ये दूसरे ट्रांसफर भी इसलिए ये जो 8 पेज नंबर 12 वो जो देखा जाए पेज नंबर 12 whether the learned courts below had not come to erroneous finding in declaring the suit without giving separate finding on exhibit C and D, which are the registered deed of surrender, exhibit C, and registered deed is exhibit D is the settlement registered, prepared long before declaring the suit and which were not challenged at any point of time, which I was advancing my argument. Number 1. Number 2, Your Lordship may kindly come to 10. Whether the learned courts below ought to have considered that the suit has been filed by the plaintiffs only against 2 plots and whole property of the alleged surrender deed as well as the settlement deed are not the subject matter of the suit. And third is below 13. Whether the appellate court while hearing the appeal has exercised the power in true perspectives as looking to settle law, it is the duty of the first appellate court to appreciate the entire evidence. एक चीज जो appellate court का judgment दिखा दें, कोई discussion नहीं, सीधे कर दिया ट्रायल कोर्ट जो किया है सही. I just show your Lordship. While doing so, the judgment of the appellate court must reflect the conscious application of mind and record findings supported by reasons or.
The learned counsel for the applicant has submitted that the principal defendants were claiming title over the suit property by virtue of registered deed of surrender dated 24/29.
Exhibit C.
Exhibit C. And registered deed of settlement dated
29/3/31.
29/3.
Yes.
29/3/1931. With the
Exhibit D.
Within bracket Exhibit D. And these registered documents were never challenged by the plaintiffs.
And still not challenged in this present suit.
And even if it is assumed that Luthi Madhyain was minor at the time of execution of surrender deed dated 24/1/1929, the learned counsel submits that
Even the age of Ludhi Madhyain has not been determined by the court.
the learned counsel submits that the surrender, the registered deed of surrender and registered deed of settlement having not been challenged by the plaintiff, the suit could not have been defeated by ignoring these documents.
Yes.
And it could not have been held that
There are 10 of the appellate court
held
judgment.
that the deed of surrender was itself void argument. यही hold किया ना?
The appellate court did not discuss anything. Para 10 recorded the finding concurring.
Concurrent finding में बहुत ज़्यादा discussion
फिर भी थोड़ा सा भी तो हुजूर लिखेंगे ना एग्जीक्यूट क्या है, एटलीस्ट डिस्कस तो करें थोड़ा बहुत भी, क्योंकि फाइंडिंग ऑफ फैक्ट है. The appellate court is the final court of fact.
The learned counsel has submitted that the deed of surrender at best could have been a voidable document.
In the event she was minor,
In the event she was minor,
and her age would have been determined by both the courts. No court has determined what was the age.
the same cannot be said to be null and void. यही आपका कहना है. After hearing the learned counsel for the appellant, this appeal is admitted for final hearing on the following substantial question. whether the learned court whether the learned courts were justified in holding that the deed of surrender,
Registered.
registered deed of surrender dated 24/1/1929 was void ab initio. That's all there. Issue notice to the respondents. For which requisites under speed post we filed within a week. Date. That the records be called from the concerned court. Office to track speed post delivery, postage stays on 24 of February.
10 days later. 10 दिन 7 दिन
10 days. Next week, 25th, office to track speed post.
21st.
This is already communicated.
Orders be defect item 9, second appeal 233 of 2023.
There are two items, one IA 9741 for deleting the name of the applicant number 1 matter, put ID to OP.
Item number 9741.
9741.
Item number 9741 of 2025. This petition has been filed for deletion of name of applicant number 1, who is said to have expired on
1/1/2024.
1/1/2022.
24.
2024 by stating that applicant number 1 died leaving behind the 2 sons and 1 daughter.
They are already made in party.
Who are already
Made in party is already made.
party in the present proceedings.
Yes, ma'am. Para 4.
As applicant number 2 to 4. Correct?
Yes, ma'am.
He submits that the name of applicant number 1 is considering the submissions. IA number 9741 of 25 is allowed. Housing for the applicant is directed to delete the name of applicant number 2 in the cost item in waiting to other one.
There is one IA 9742.
Means what is it?
Under chapter 22, rule 96. In this, they deputy pointed out that the exclusion of plan number 2, 5, 11, 14 may be verified and given at the Rakamani. So, same measurement removed by way of filing place for Rakamani.
File fresh for the
Yes, madam. As per degree, madam, I filed place for Rakamani. And so far, defect number 7 is concerned, madam. Apply number 6 to 9 of the memo is not party in CCO degree under appeal. It appears that they are legal heirs of receipt as mentioned in page 2 of memo, proper step may be taken for substitution. Therefore, madam, I filed petition under chapter 22, rule 96. Says that before pronouncing of judgment and degree, one of the party have died and they have not. It has not been informed to the learned court below, and degree has been made against that person. Thereafter, the
And
applicant.
who died? Who died prior to victim?
Yes,
And when did he die?
Brahmdev Prasad Agarwal, page 24.
He died when?
Yes.
When did he die?
Died of 25/6/2023. 25/6/2023, and judgment has been delivered, my lord, after 10 days, 5/7/2023.
When was the judgment reserved?
Judgment pronounced on 5th July 2023.
When was it reserved?
It has not been mentioned in the judgment, my lord. Degree has been prepared, my lord. 15th July 2023. But many members of the applicant were engaged in the start ceremony, my lord. Therefore, could not be informed to the court.
You were the Brahmadev Prasad Agarwal was the respondent.
Was applicant in the non-court below and defendant in the suit.
And you are you have lost in appeal.
Lost in appeal and suit also.
So whose responsibility was there to inform the court? Your responsibility.
Your no, my response.
So,
But what was due to start ceremony, I mentioned start ceremony, the family members are engaged in the start ceremony, therefore could not inform to the court below, and in the meantime, the judgment has been passed.
he died when on 25/6.
25/6/2000.
The ID number. Nine 742/25. This petition has been filed under Chapter 12, Unit 26 of High Court of Jharkhand, 2001, and Section 151 of CPC in connection with two defects. With respect to defect number 6 and 7 as pointed out by the statute order dated 17th, the learned counsel submits that so far as defect number 6 is concerned, the same has been removed by filing a fresh Wakalatnama on behalf of applicant number 2, 5, 11 to 14. Full stop, office to pay. With respect to defect number 7, the learned counsel submits that it has been pointed out that applicant number 6 to 9 were not party in the decree under appeal. He submits that Brahmadev Prasad Agarwal died on 25/6/2023, and the judgment of the first appellate court was pronounced on 5th of July 2023. The learned counsel has also referred to the page number 2 of the appellate court's judgment to say that the date of final hearing of the appeal was 26/2023. He submits that after the conclusion of final hearing in appeal, the final hearing in appeal, Brahmadev Prasad Agarwal died after 2 days, and after his death, within a couple of days, the final judgment was pronounced. Correct?
Yes.
ये जो कहता है this is after pronouncement of decree होता है कि after conclusion of judgment?
After conclusion of judgment. After conclusion of an argument or before passing of the judgment, if he died.
If he dies,
It
then this is applicable. This provision is applicable.
Yes.
Are you sure?
This is the rule.
है rule है?
96.
Are you sure? Under our rules, if the judgment is reserved
Yes.
and a person dies,
Yes.
then he is entitled to. Then there is no question of any substitution at afterwards.
No, Lord, chapter 12, rule 96.
Okay.
Jharkhand High Court.
Chapter 92.
Chapter 12, rule 96
96.
provides, Lord, that an application has to be filed and the court may allow.
Application before this.
Before this, yes.
Before
Before this court, yes, yes. Before this court.
But no steps could have been taken before that.
It could not have been.
Considering the aforesaid submissions, the defect number 7 is ignored for the present. That's all? So there I said.
Yes.
Office is directed to place this case under appropriate hearing. It is subject to any objection that may be raised by the respondent. Under appropriate hearing on next month. Are you listening?
Item 10, CMP 177 of 2024.
There is a two one I is for one I number 12965 for limitation condemnation of delay 32 days. Second, of the order. There was the order to remove the defects within 2 days, but due to COVID period, defect was not removed. So, this was discussed.
There is a petition for condemnation of delay. There is one more petition
Yes,
also.
Lordship. Another petition is Lordship IA number 12771 of 24. This is for the Lordship leave to file restoration petition.
CMP number उनका डेथ सर्टिफिकेट लगाएं.
Yes, Lordship, appellant died on 6/11/2020. Lordship.
Where is the death certificate?
Yes, Lordship, annexed to case 61.
Of the main petition.
Yes.
Yes. CMP number 177 of 2024. This petition has been filed for restoration of security number 161 of 2019, which was dismissed for default on account of non-removal of defects pursuant to order dated 3/11/21. The learned counsel submits that the sole opinion expired during COVID period on 16/11/2020. Submit that ID number 12965 of 24 has been filed seeking condemnation of delay of 650 days in filing the instant petition. ये revision file ही है इसमें. She also submits that another IA being IA number 12771 of 22 has been filed seeking leave to file the restoration application on behalf of the legal heirs of the sole applicant. Considering the submissions, I number 1277 1277 of 24 is hereby allowed, and the petitioners are permitted to pursue the present CNP seeking restoration of the second appeal. Issue notice in item number 12965 of 2024 as well as in the CNP to the respondents. और तो कोई डिफेक्ट नहीं है ना इसमें? To the respondents as a speed post for which requisites be filed within a week. दोनों में फाइल करें. Limitation में भी नहीं. Office to track speed post delivery post on 23rd of February.
Item 11. Second appeal file number 8948 of 2024.
Yesterday I have received the wakalatnama NOC Manoj.
Sir, fine. It effective है.
Yes.
So,
I'm playing some time Manoj. I have to see the records Manoj. Because there was a substitution also which has to be carried out Manoj. And there were certain things which has been said in IA number 2812 Manoj.
you have filed your wakalatnama?
No Manoj. Today I'll be filing.
कहाँ है बताओ? अभी कुछ नहीं है से
स्टार्ट जैसे दिया गया वैसे अभी लाए उसमें भी डिफेक्ट है उसके लिए मैं बोला कि ये करने के लिए इट हैज नॉट बीन प्रॉपर्ली
अच्छा ही अपनी बात ही रखिए
इसलिए हम नहीं कर रहे हैं
filing number XA948 Mr. Harsh
मिस्टर कुमार हर्ष
Mr. Kumar Harsh, advocate, submits that undertakes to file fresh wakalatnama by tomorrow,
by tomorrow Manoj.
within a week.
Yes.
Within a week. He submits that he has to instruct the record and get ready.
Yes.
आप क्या करेंगे भाई?
नहीं हमको नोटिस हुआ था आईए पे
आइए क्या?
बट आईए इनका डिफेक्ट रिमूव करने वाले आईए पे कुछ नोटिस हुआ था तो उसी में कुछ लोग के तरफ से अपीयर किए
ठीक है, let him inspect the records when you want the matter.
So after 3 weeks.
At his request, post his case on 7th of December. 3 weeks after 3 साल वकालतनामा फाइल करने के बाद आपको 3 हफ्ता फाइल रिकॉर्ड करें.
नहीं 153 2006 का भी एक और मैटर है इसलिए व्हाट आई एम सबमिटिंग Manoj कि दिस इज सेकंड राउंड ऑफ लिटिगेशन
कोई बात नहीं, आप
उसमें substitution-
एकदम शुद्ध दिन निकालें आप. 3